and welcome everybody. Thank you so much for joining our webinar. We're going to be covering the new issue paper, Montana Supreme Court, an institution in need of reform. With legislation increasingly facing frequent legal challenges, many people have approached us concerned about the appearance of bias in our courts. To make matters worse, media coverage of court issues often fails to seriously investigate accusations of bias. So members of the public, especially those of us without a law degree like myself, are left in the dark and without real answers for what's going on. And I think that's a problem, especially when, Montanans are asked to vote for judges in a nonpartisan election. So at Frontier Institute, we believe that Montanans are in need of some serious independent analysis to educate lawmakers and the public about judicial issues. So we decided to start that project by commissioning an issue paper from a preeminent authority on constitutional law, a former professor of law at the University of Montana, and a senior fellow at the Independence Institute of Colorado, Professor Rob Natelson. In his new issue paper, Professor Natelson lends his expertise to assess the Montana Supreme Court's activity according to key indicators of the rule of law. Tonight, you'll hear Professor Natelson dive into some of the key points of the paper, and you'll have a chance to ask questions along the way. As we move forward with the presentation, you can type your questions in the Q&A option at the bottom of your screen, or you can wait until the end of the presentation and raise your hand, where I can unmute you and allow you to ask your question directly. One last note, in tonight's discussion, we want to try not to get into the weeds of specific cases. So if you have questions about a particular case that was mentioned, Rob's happy to talk to you directly offline. We also won't be getting too far into recommending policy solutions for the issues raised. That's a whole other can of worms that we're going to be working to address another time. So our purpose here with this webinar and the accompanying issue paper is to provide you with a deeper understanding of the Montana Supreme Court's activities over the last decade, what aspects of the court's activities may be driving concerns of bias, and give you a better grasp of the principles of sound constitutional jurisprudence that we should strive to uphold. So with that, Professor Natelson, take it away.
Thank you, Kendall. Good evening. Thank you for joining us. I'd like to acknowledge several people for their help with this paper. One is Kendall Cotton, who not only commissioned it, but assisted the process in many ways. Another is Andrew Morris, who is professor and formerly dean at the Texas A&M University Law School. Professor Morris has written extensively on Montana history and law. I'd also like to thank Liam McCullum, who attends the University of Montana School of Law, for his help with case citations, Senator Greg Hertz and Senator Tom McGilvray for their contributions. I also benefited from the input of many Montana lawyers and citizens whose names are being kept confidential to protect them against retaliation. The issue paper says this is the second survey I've done of the Montana Supreme Court, the first having been completed in 2012. That's true, but actually I've been working with Montana Supreme Court case law for a lot longer than that. In fact, dating back to 1990, when I wrote the first of several articles for the Montana Law Review. The 2012 study was commissioned by the Montana Policy Institute. It surveyed Montana Supreme Court case law over the previous 3 decades, that is from 1982 to July 31, 2012. This new paper picks up from that, covering the period from August 1, 2012 through the end of 2023. But this paper also puts that period in wider context, and it discusses one paper from 2024 that the court issued just before publication. In writing this paper, I used a variety of sources. All Montana Supreme Court cases decided since August 1, 2012 were subjected to at least some database analysis. I examined closely many leading cases and all the court's decisions on constitutional law issued since 2012. I also conducted interviews, examined news articles and other documents, and took into account recent scholarship on the Montana Supreme Court. You'll find that material cited in the footnotes to the paper. I also factored in my own article published in 2018 on the adoption of the Montana Constitution. That article is by far the most thorough and heavily documented publication on the Constitution's ratification. Much of it is written in easily understood language, so if you're interested in Montana history and public affairs, I strongly recommend it. The purpose of this new paper is to describe and explain the activities of the Montana Supreme Court. It does not propose solutions, because proposing solutions will require additional research and another paper at least as long. Perhaps one day the Frontier Institute will commission such a publication. In the meantime, the content of this paper and what I say tonight may suggest some ideas. Now, there's an important background fact that you need to know. It's this: compared with other state Supreme Courts, the Montana Supreme Court is a very powerful institution. By that I mean the Montana Supreme Court can exercise far more influence in its state's political and judicial system than the highest tribunals of most other states. There are several reasons the court is so powerful. One is that Montana has no intermediate appeals court. In states with intermediate appeals courts, most cases end after one appeal and the Supreme Court never sees them. And cases that do come to the state Supreme Court often are framed in a way that limit the justice's discretion. But in Montana, the Supreme Court can hear all appeals from trial judges. In addition, the Montana Supreme Court sometimes takes original or trial jurisdiction in important cases, thereby acting as judge and jury, and sometimes as executioner. Let me be clear that I am not recommending that Montana create an intermediate appellate court. I'm simply explaining one contributor to the Supreme Court's power. Another factor adding to the court's power is this: in some states, control over attorney discipline is fractured among several different entities. But in Montana, attorney discipline is centralized in the Supreme Court and in certain agencies it oversees. This central control creates opportunities for abuse, as demonstrated by the current disciplinary action against Attorney General Austin Knudsen for his criticism of the court. The risk of centralized control of attorney discipline is further illustrated by a current scandal in Colorado, which has a similar system, where the state Supreme Court also has abused the disciplinary process to attack its critics. A third factor contributing to the court's power is that Montana has what is called an integrated bar. Now, this has nothing to do with racial integration. An integrated bar means that lawyers not only are required to take the bar exam and be licensed, which is true in every state, but they also are required to join the state bar association. The Montana Bar Association was created by the Montana Supreme Court, and it serves, at least indirectly, as an instrument of control. By the way, forcing a lawyer to join an organization like the Montana Bar Association may well be unconstitutional under the US Supreme Court's 2018 Janus decision. A fourth contributor to the court's power is the lack of outside critical commentary. In Colorado, the scandal I just referred to has been thoroughly aired in the media. And in fact, a former Chief Justice was actually disciplined for improper conduct. But all too often, the Montana media are uninterested or uninformed about the court's problems, or they're even protective of the court. As for scholarly criticism, that's supposed to come from law professors. But Montana has only one law school, and the relationship between the Montana Supreme Court and the law school is, very cozy. During my 24 years on the faculty, the law school regularly held events to honor the justices, and the pressure to avoid publicly criticizing them was intense. When I nevertheless did criticize one of the court's decisions in public, there were serious repercussions. For all these reasons, and perhaps more, the Montana Supreme Court is a very powerful institution. As explained in my paper, it is also political and sometimes arbitrary. Many Montanans know this, but they assume all judges are political and arbitrary, that they're all like that. But that's not true. They're not all like that. Lawyers and judges are part of a profession. As in other professions, there's a spectrum within which professionals may disagree. But there are also boundaries. And when you go outside the boundaries, you venture outside the realm of good practice. Suppose a man has a serious heart murmur. Two cardiologists may disagree on exactly how to treat him. But no reputable cardiologist would suggest that the treatment be, let's put on grotesque masks, chant, and shake rattles over the patient. A suggestion like that would be deviating outside the boundaries of good medical practice. Similarly, there are limits to good judicial practice. Americans got a lesson on this point recently when the US Supreme Court ruled 9-0 that states could not disqualify former President Trump from the ballot. Now, there are several justices on the US Supreme Court who do not care for Donald Trump, but they understood that part of a judge's role is to put personal opinions aside and rule on the law, and they did so. To summarize here, courts and judges often differ within professional boundaries. The problem with the Montana Supreme Court is that it frequently wanders outside of professional boundaries. Later in this presentation, I'll provide some more examples, but let me just give you one now. This is a little technical. The Montana Constitution, like the US Constitution, grants the courts what is called, quote, the judicial power. The judicial power may seem like a vague phrase, but it is not. The meaning and scope of the judicial power has been defined and refined over centuries by courts in England and America. When a court goes outside the defined limits of the judicial power, it exceeds its constitutional authority. Staying within the judicial power includes not wandering into the legislative and executive powers, but it's more than that. It also means turning down certain cases and requiring anyone who wishes to maintain a lawsuit to qualify as a proper plaintiff. To qualify as a proper plaintiff, you have to have standing to sue. If you have standing, you may get into court. If you don't, you won't. The Montana Supreme Court says it applies the US Supreme Court's rules of standing, but it really does not. For certain favored classes of plaintiffs and certain favored classes of cases, the court either fudges the standing rules by, for example, creating this is the court's word, public interest exception, or it just ignores the standing rules. Such behavior is not within accepted judicial norms. One last background fact. None of the judges is innocent. I know some justices are considered more conservative or more restrained than others, or they advertise themselves as such. And it is true that some justices dissent from improper conduct in some cases, but all participate regularly in that conduct. During the period covered by this paper, some of the most questionable decisions were not only agreed to, but written by justices who some think of as conservative. My 2012 study tested the court against 5 widely accepted components of the rule of law. I also used those 5 components in this paper. As you can see from the slide, they are clarity, stability, notice, fairness, and judicial restraint. Let's start with clarity. In order to comply with the rule of law, a court's decisions must be clear. If they're vague or ambiguous, they leave people uncertain as to what the law really is. Unclear precedents also create opportunities for judges to unfairly manipulate the rules in later cases. The 2012 study found many instances in which the court's decisions were, as that study put it, as clear as mud. When researching this paper, I investigated whether the lack of clarity has improved since 2012. Now, as far as I know, there's no objective way to measure judicial clarity. But my subjective impression from reading the court's decisions since 2012 is that the situation in this area has improved. It seems that there are more clear opinions now and fewer unclear ones. And since I'm issuing a lot of criticism today, let me add one item of praise. Justice Beth Baker, in particular, has contributed to the improvement in clarity and to the quality of judicial reasoning in general. She's also one of the more judicially restrained members of the court. Still, problems with clarity persist. Let's examine a prominent case example. The case is Board of Regents of Higher Education versus State of Montana. In 2012, the legislature passed a law allowing the concealed carry of firearms throughout the states, including on state university campuses. The Board of Regents objected to allowing firearms on university campuses. The Board of Regents, was the exclusive regulator of the campuses. The board sued, and it won in the Montana Supreme Court. I think the justices got the result wrong, but that's not the point I want to make here. Rather, it's a point about clarity or lack thereof. Justice McKinnon wrote the court's opinion. Here are 2 key sentences from it. They discuss how the court interprets the state constitution. The first sentence says, quote, "We must discern the framer's intent from the plain meaning of the language used, and may resort to extrinsic aids only if the expressed language is vague or ambiguous," end quote. So that tells us that if language in the Constitution is clear, we apply it, we don't inquire further. But the very next sentence says, quote, "Even in the context of clear and unambiguous language, however, we determine constitutional intent not only from the plain language, but also by considering the circumstances under which the Constitution was drafted, the nature of the subject matter the framers faced, and the objective they sought to achieve." So the first sentence tells us that if the language in the Constitution is clear, we do not go further. And the second sentence tells us that we do go further. This is an extreme example of lack of clarity, but unfortunately, it's far from the only one. My paper documents other examples. The second component of the rule of law is stability. In order for people to know the law and follow it, the law must not change too quickly. This means courts should respect case precedent. Of course, there's some occasions when it's necessary to overrule case precedent, but occasions like that are comparatively rare. So most courts stick to precedent in nearly all cases. But that's not true of the Montana Supreme Court. Until recently, this court was overruling its own decisions at a frenetic rate. This chart comes from the 2012 study. It compares the overruling rate of the Montana Supreme Court with the highest tribunals in states that, like Montana, do not have an intermediate appeals court. As you can see, during the decade 1992 to 2002, the Montana Supreme Court was overruling its own cases at a rate double that of the next highest state and several orders of magnitude more than average. This is another example of what I mean by judicial behavior that deviates from the norm. You might ask, well, did this frantic rate of overruling continue? The answer is, during the decade from 2002 to 2012, yes, it did continue. Fortunately, though, when researching this paper, I found that the rate of overruling has slowed. So the good news is that while the rate of overruling is still somewhat high, it's nothing like it used to be. But the bad news is that the court often overrules precedents in a way that doesn't show up in a database. It does this by simply disregarding precedent rather than formally overruling it. Consider Espinoza versus Montana Department of Revenue, where the opinion for the court also was written by Justice McKinnon. The state legislature passed a bill allowing taxpayers to take an income tax credit of up to $150 for contributions made to a scholarship fund for school children. Children could use the scholarships to help pay tuition at any private school, religious or secular. The idea was to promote school choice for families of modest means. But the Department of Revenue slapped on a rule prohibiting the use of scholarships at religious schools. As I'll explain later, the case was supposed to be about whether the Department of Revenue exceeded its power in making the rule. But the Montana Supreme Court ignored that issue and held that the law itself violated the state constitution. Yet, as Justice Baker pointed out in her dissent, one of the court's own case precedents held that including religious organizations in programs like this did not violate the state constitution. Still, the court did not overrule that case. It just didn't mention it. In fact, in effect, that's an overruling, but it doesn't show up in the statistics. As you can see from the slide, the U.S. Supreme Court eventually reversed the Montana justices' decision. What the Montana justices, aside from the dissenters, Baker and Rice, what the Montana justices refused to understand is that discriminating against a religion or among religions violates the First Amendment of the U.S. Constitution. The next component of the rule of law is notice. This means the court should ensure that people whose rights will be immediately affected by a case are notified and given an opportunity to tell their side of the story. Due notice is more than a component of the rule of law. It's also required by the United States Constitution and the Montana Constitution. The 2012 study found the court's failure to give due notice was a problem. And more recent cases show that failure to give due notice continues to be a problem. A good example is in the Espinoza case, which I just mentioned. The issue in that case was supposed to be whether the State Department of Revenue had any power to issue its rule taking religious schools out of the scholarship program. But without notifying any of the parties or anyone else in advance, the court turned the case into a constitutional challenge. In Justice Jim Rice's dissent, he quite properly pointed out that this violated due process. Another notice failure occurred during the so-called McLaughlin controversy in 2021, where the court got into a battle royale with the legislature and the Attorney General. The legislature issued a subpoena to the State Department of Administration, but the court quashed it on a Sunday without prior notice to the legislature that issued it and without any opportunity for the legislature to make its case. The fourth component of the rule of law is fairness. It's the job of a court to dispense justice equally, without regard to whether the parties are rich or poor, white or black, liberal or conservative, Democrat, Republican, or independent. Justice is blind. But the Montana Supreme Court operates very differently. Its decisions are systematically biased in favor of liberal interests and liberal parties and against conservative interests and conservative parties. This bias shows up in many different ways. There's the privileging of environmental rights over property rights, which I'll discuss more in a moment. There's the privileging of government regulation over economic rights, and the privileging of liberal litigants and liberal causes over conservative litigants and conservative causes. In a recent opinion column, Senator Greg Hertz gave an example of how the court privileges liberal litigants over conservative ones. A conservative interest group challenged a Montana law as unconstitutional. It was a long and difficult battle, but the conservative group won the case in the United States Supreme Court. It then asked for an award of attorney's fees, which the Montana Supreme Court denied. But in a more recent case, a liberal interest group challenged a Montana law as unconstitutional. The state hardly defended the law, so the liberal group's victory was easy and swift. In other words, the liberal group had little need for attorney's fees, but it still asked for them. Under the rule applied in the earlier case, the liberal group's request should have been denied, but the Montana Supreme Court awarded attorney's fees anyway. Those two cases are also discussed in my paper. Possibly the easiest way to see the court's bias or to measure it is to compare how it treats challenges to conservative and liberal ballot issues. And by ballot issues here, I mean citizen initiatives and legislative referenda. I identified all the challenges to ballot issues over the last 40 years. Then I distinguished those ballot issues that were clearly conservative from those that were liberal, leaving out those that were hard to categorize. And I compared how the court treated the conservative issues and the liberal issues. On this slide, you can see the record. All the liberal ballot issues, every one of them, were upheld, but almost all the conservative ballot issues were struck down. And in one of the few instances in which the justices upheld a conservative ballot issue, the one marked with an asterisk, a hostile and inaccurate fiscal note had already destroyed its political viability, and it never appeared on the ballot. The final component of the rule of law is judicial restraint. This is an area in which the court continues to earn very low marks. Earlier, I referred to how the court allows favored plaintiffs to sue without compliance with the traditional rules of standing. This enables the court to rule on issues it should not be ruling on. Another aspect of lack of judicial restraint is the court's continued arrogation of power to itself by using and expanding 3 decisions it issued in 1999. 3 decisions I call the toxic trio. The toxic trio and the more recent decisions built on them are discussed at length in my paper. In the first one, Marshall versus Montana, the court assumed to itself an absolute veto over amendments to the state constitution, thereby preventing the people from reversing its decisions. Montana Environmental Information Center versus Department of Environmental Quality assumed a veto over state environmental policy. Armstrong versus Montana took power over abortion policy. All 3 cases were marked by serious judicial lapses. They're rare examples of cases that should have been overruled, but instead the court has followed them and even expanded them. Well, you might ask, why does the court act as it does? I can't answer the question completely. I can mention two factors that contribute to the problem. I'm aware there are some Montanans who consider the 1972 Constitution to be a document of unmitigated evil. And I know there are other Montanans who think it's holy writ. But I think the truth is somewhere in between. It has many strengths, but it also has serious defects. Among those defects are instances of vague, contradictory, and undefined language. A traditional court might deal with this lack of clarity. A traditional court might deal with this lack of clarity by adjudicating only around the edges and leaving the details to the legislature. But the Montana Supreme Court seems to see the Constitution's vague, contradictory, and undefined phrases as opportunities for judicial activism. Also, in construing the Constitution, the justices usually apply an erroneous rule of interpretation. As a general matter, constitutions, like laws and other documents, should be construed according to the intent or understanding of those who adopted them. Laws, for example, according to the intent of the lawmakers that made them. The people who adopted the Montana Constitution were the voters, who are said to have ratified it on June 6, 1972. Although we can't directly know the understanding of each voter, we do have a fair amount of information about how the proposed Constitution was explained to them. For example, the voters were told explicitly that the document's environmental rights were to be worked out by the legislature and were not enforceable in the courts. The voters also were told explicitly that the Constitution would have no effect on abortion laws. But the Montana Supreme Court almost always disregards how the Constitution was represented to the voters. Instead, it relies on something it calls the intent of the framers, meaning the transcript of the Constitutional Convention that drafted the document. The court relies on the transcript even though the transcript was still unpublished when the Constitution was adopted and the voters had no access to it. Instead, they relied on the voter information pamphlet and other writings, a wholly different set of materials. So why does the court rely on a transcript the voters couldn't see? In the paper, I speculate as to some reasons, but whatever the reasons, relying on the convention transcript and disregarding what the voters were told has the effect of biasing the court's decisions in a leftward direction. Still, defects in the state constitution and an erroneous rule of interpretation don't explain most of the problem. For example, the Montana Constitution protects both property rights and environmental rights in the same section of the same article and in the same way. Yet the court protects environmental rights with strict scrutiny while giving property rights almost no protection. In this instance, therefore, you cannot blame the Montana Constitution for the court's conduct. Here are some other possible reasons the court acts as it does. First, its high level of power may encourage abuse. Next, judicial elections are nonpartisan, so political parties cannot disseminate information about judicial candidates or about justices seeking re-election. On the other hand, special interest groups that benefit from liberal court decisions do participate heavily in those elections. Third, I have to report the court has suffered from a shortage of really good judicial talent. And finally, the justices seem unaware of how some of their actions appear to people outside in the general public. One example of this is how they responded to the discovery of the illegal lobbying in the McLaughlin controversy. As mentioned earlier, specific solutions will have to come in a future paper. But one thing is clear, we need more public education on the court. Perhaps a good way to begin would be to develop a scorecard for justices and judicial candidates, similar to the scorecards used to rate lawmakers. And we also need some people to stop proclaiming to the public that the 1972 Constitution is holy writ and without flaw, and to acknowledge that it has serious defects that do need to be addressed. The conduct of the Montana Supreme Court continues to be a serious problem, and it will continue to challenge you. For example, I'm told that the legislature's limit on money damages may soon come under fire, as they have been before. But at stake here is nothing less than representative government itself. Is Montana to be governed by her elected representatives or by a judicial oligarchy? Is Montana to be governed by the rule of law or arbitrarily? The stakes are high enough that lawmakers and other opinion molders need to do the right thing, even if the right thing is the tough thing. Don't listen to self-interested whining by special interests and uninformed complaints by the media. Don't be intimidated. Do what is necessary and explain to everyone while you're doing it. Again, the choice is a democratic republic or judicial oligarchy, the rule of law or the arbitrary will of masters. How you make that choice is up to you. Thank you all very much for coming tonight.
Excellent. Well, thank you so much, Rob. And I'm going to kick off our Q&A here. And I'll just kick it off with a question that I had that I noted as you were doing your presentation. I think that this point that you made about the court relying on the intent of the framers rather than the ratifiers was really interesting. And it seems like this is something that should come up in arguments before the court, but it doesn't seem to be an argument that's used very much. Can you expand on why that would be? And is there something that could be done differently to hone in on that as an argument?
Part of the confusion here is that jurists, and not just the Montana Supreme Court, jurists also often loosely talk about the intent of the framers. Of course, when they really get down to, take the US Constitution as an example, when they really get down to interpretation, the question is, when the US Constitution was adopted, how was it perceived in the 13 ratifying conventions of the 13 states, not what went on behind closed doors in the Constitutional Convention. And the same rule really is applicable here. I mean, think, for example, of the legislature. I mean, how do you interpret statutes? Do you ask what the intention is of the lawyers in the legislative drafting office who put it together? No, you don't. You ask what was the intention of those who actually converted it into law, the ratifiers. A part of it then with the Montana Supreme Court may simply be a failure to understand that. But there also are, and I mentioned this in the paper, there's some concrete reasons why they may be focusing on the understanding of the intent of the framers instead of the understanding of the ratifiers. One is that the Constitutional Convention transcripts are very available, very easy, they're indexed. That excuse has less validity now because a law professor at the University of Montana, who shall remain nameless, just before he left the University of Montana in 2010, actually collected all the ratification documents on one website. And you can get it at the University of Montana Law School. Basically, my daughter and I put this thing together. And so you can read an enormous collection of ratification documents. So the accessibility excuse is not as strong as it should be. In addition, you've got a lot of former Constitutional Convention delegates very proud of their work, and they're willing to make a noise to protect what they see as their handiwork, and sometimes even to sue in order to protect their handiwork, even though their handiwork might have been represented differently to the voters. And then the most Machiavellian explanation, Kendall, is simply that you know, uh, sometimes when you look at the intent of the framers, you get more liberal results than if you look at the understanding of the ratifiers. Abortion is a good example. You have basically one comment by my good friend Bob Campbell at the Constitutional Convention, where he says that the Montana right to privacy might contain more than merely protection against surveillance. And then they turn that into an evolving right, which includes abortion, and they ignore all the representations at the founding, during the ratification campaign, that abortion would not be affected by the Constitution. So those are some speculations as to what the reasons might be, but let me just say that there has been some growing awareness of the problem. When I researched the literature, meaning the scholarship of the Montana Supreme Court, I found 2 articles written in the last few years by students, interestingly enough, at the University of Montana Law School, who sharply criticized the court for relying too much on what went on in the Constitutional Convention and ignoring what the voters were told. And one of them, in fact, documented that the court had interpreted the Constitution using the intent of the framers something like 168 times, but hardly ever mentioned the understanding of the ratifiers. So there is kind of a growing recognition that this could be an issue.
Got it. Okay. Thank you for that. That definitely clears things up on my end. I want to remind everybody that you can ask a question now. You can either type it in to the Q&A at the bottom of your toolbar, or I believe you should be able to raise your hand and I can call on you virtually and get you on to speak. But let's start with, we have a question here, Rob, from Bart. And Bart, I'm going to answer this live. And so I'll just read it to you, Rob, and then we can have a discussion. Bart says, would you agree that a part of the problem within our judiciary accountability is that our judiciary self-disciplines? Lack of accountability empowers our courts to operate outside of their boundaries because they will act with impunity. Would you agree? Would you not agree? We, the people, need a Citizens Oversight Commission rather than the current Judicial Standards Commission.
I'm not prepared to endorse a particular proposal, but I generally agree with the statement by the questioner that, and I actually touched on this, that the idea that the judges are wholly self-disciplining and the Montana Supreme Court is wholly self-disciplining is a problem. I mentioned, for example, that Colorado, where I'm licensed, and by the way, people should know that one reason I can speak freely on this issue is that even when I was teaching for the 24 years I taught at the University of Montana Law School, I avoided getting a Montana license. I kept my Colorado license precisely because I didn't want to be subject to censorship. In Colorado, they have a similar system whereby, you know, the discipline is concentrated in the state Supreme Court, and they've had some serious scandals as a result. The difference is they've been aired in the media in a way that the media doesn't air the Montana scandals. So yeah, I would say there need to be more checks and balances here. Look, for example, at the complaint against the Attorney General, Austin Knudsen. Based on things that he and staff members said, which as far as I could tell were pretty accurate during the McLaughlin controversy. The complaint was brought by a California lawyer who has a Montana license, or at least it was initiated by her. It was then formally brought by one entity under control and supervision of the Montana Supreme Court. It will be tried by another entity under the control of the Montana Supreme Court. And if you don't like the opinion, you can appeal to, guess where? The Montana Supreme Court. That's a serious due process issue, in addition to being a recipe for lack of public accountability.
Okay, I think we're going to go to a live question now. Let's see, Becky has her hand raised. And Becky, I'm going to try to allow you to come on and speak here. So Let's see if this works. All right. Becky, if you unmute yourself, you should be able to speak.
All right, there you go. Can you
Excellent.
hear me? Okay.
Yes.
Professor Natelson, thank you for doing this, for presenting this tonight. It was about a year ago I began working on a conceptualization of a constitutional amendment. And I went back to look at some of the documentation regarding the testimony and debates on during the Constitutional Convention. And there were a number of delegates there who did question the intent of this, that, and another thing. And I was wondering, being a current member of the legislature, where we're learning that intent does speak loudly if we can cite it, if we can go back and maybe do a deep dive into those debates that took place during the convention to further define the parameters of the Constitution, that has kind of fallen through the cracks on some of these issues, especially private property protection.
Mhm. Yeah, the intent at the convention is important and interesting, but as I mentioned, it should not be the intention that controls. And that's where the Montana Supreme Court has it wrong. The intention should be what was told to the voters. You know, the voters in 1972, let me back up. The convention itself was overwhelmingly liberal. They won a landslide victory. Even some of the Republicans elected were old style progressive Republicans. But the voters remained somewhat more conservative. And so when the Constitution was presented to them, it tended to be presented in a way to say, you know, this really is not an enormous change. That having been said, Becky, it's true that there simply are some parts of the Constitution that need to be amended. For one of two reasons, either because the Montana Supreme Court made a mistake and a constitutional amendment has to correct them, or because maybe the framers and the voters got it wrong the first time, and we need to amend it. I mean, this is not a document that, you know, as I mentioned, that's holy writ. I suspect, I don't want to speak for Kendall here, but I suspect that the Frontier Institute will be exploring those issues in the near future. The one big problem that people face, though, is the first one in that toxic trio of cases, the Marshall case, which has been reaffirmed by the court several times, which strikes down conservative, which has resulted in conservative constitutional amendments being struck down. Incidentally, the same standard was not applied to a liberal constitutional amendment recently, but it makes it difficult to get conservative constitutional amendments through the court. But by all means, the legislature should try. The only thing I would counsel is that drafting constitutional amendments is not something for amateurs. Even the legislative council isn't necessarily skilled at drafting constitutional amendments. So really make sure that you've got competent counsel to do it. Because if you don't, any number of things can happen. Number one, defects in it will be pointed out during the campaign and it will be defeated, or it will have effects that you really didn't want to happen, or it will not have the good effects that you want to occur. So when you do that deep dive and come up with suggestions or ideas that you want to see changed, be careful with the drafting.
Excellent. Let's see, we have quite a few questions popping up on our written Q&A. So let me read a couple of them to you, Rob. We'll start with Bruce here. Bruce is asking, why are the court justices elected seem to be much more liberal than the legislature? Is it messaging or some other factors at play? So I guess, you know, the in a broad sense, the question would be, do judicial elections versus appointments like some other states do, does that structure contribute in some way to more bias?
Some people believe it does. To be frank, I'm a populist. I like judicial elections, but you know, elections only work as well as the law and the structure of the elections. And there are some real problems with the way the Montana Supreme Court is elected, in my opinion, which tends to produce poor results. I don't like nonpartisan elections, for one thing. I think nonpartisan elections are just as political as partisan elections, but calling them nonpartisan simply misleads people and drives the politics underground. So only the people in the know understand who's a liberal, who's a conservative. And evidence of this is in the election of a justice who left the court shortly after the period of this current study, and that's Justice Jim Nelson, with whom I've locked horns a few times, but who I personally like. Justice Nelson was about as left-wing as American jurists get. I mean, he was very, very judicial activist and on the judicial spectrum, very far left. And yet, when he came up for retention elections in counties like Flathead County and Ravalli County, places that are deeply conservative, he'd win 2/3 of the vote. Now, how does that happen? It happens because there are no parties out there explaining to people uh, the advantages and disadvantages of their candidates. Also, there are some special interest groups, like the trial lawyers are examples, who participate very heavily in the election by campaign contributions. That's their privilege. That's their right under the First Amendment. On the other hand, I don't think it's appropriate for somebody who is given heavy contributions to a judge to have a case before that judge. So there should be some kind of rule indicating that a judge has to recuse himself if he's received campaign contributions from a party or from the attorney for a party. I also like district elections. I think the idea of electing of electing people by districts would ensure that the voters know more about them than statewide elections. The legislature has twice tried to establish district elections. The Montana Supreme Court twice, and in my view, completely inappropriately, has struck down the legislature's actions. Nevertheless, I think the legislature needs to continue on that course because there are really strong arguments, and I detail a few of them in the paper, why the court was wrong to argue that or to find that district elections somehow violated the Montana Constitution. So, and then there is the issue of, are we really getting the best people to run for the court? This is a complicated question. I think the answer is clear. The answer is no. We're not getting the best people to run for the court, but the reasons are complicated. And they have to do with the level of salary, 47th in the country. They have to do with the requirement of moving to Helena. I think it'd be a good idea to move the court to Billings, frankly, or to Great Falls. But people to run for the court, good people to run for the court under the current circumstances, they have to accept sacrifices that probably are a little bit too much to ask them to do. So to summarize this overly long answer, I still like judicial elections, but I think they need to be structured differently so that voters are actually informed as to the candidates that they're voting on.
Okay, thank you, Rob. I just want to remind everybody that you can either type your questions in the Q&A written form in the bottom of your screen, or you can raise your hand and we can call on you and have you speak your question verbally. But I'm going to go to another question here. We have a question that says, how much does the dismal record of the Montana Supreme Court at the U.S. Supreme Court at SCOTUS constrain what they will allow themselves to actually do in the state, and particularly when touching issues contained in the US Constitution. Rob, your take.
Well, I don't think it's going to constrain them that much, because while it is true that the court has been reversed several times over the past decade and a half, the number of cases that go up to the US Supreme Court are pretty rare. I mean, they're pretty few. I remember well when the Marshall case, when the court basically took control of over the constitutional amendment process. Remember when that case came down, we knew that the court had violated the US Constitution by changing election rules after the election was already held. That's a violation of the 14th Amendment, but we couldn't raise the money to go into the federal court system. The court is well aware of this, that most of the parties that lose are going to sort of give up. In addition, the US Supreme Court can only take a relatively few cases. You don't have an automatic appeal to the US Supreme Court. You've got to ask for a writ of certiorari, which is a Latin word meaning to be made more certain. And the court may or may not grant the writ of certiorari. It denies the overwhelming numbers of it. So there may be, minimal constraints from the fact that the Supreme Court of the United States has overruled the Montana Supreme Court several times in the last 2 decades. But I don't think those restraints or constraints are going to be significant. It's going to be the people of Montana that are going to have to take this particular bull by the horns.
Excellent. Okay, we'll go to another question here. Can you expand on the downsides of having an integrated bar? And are there additional downsides arising from the bar being a creation of the court? Do you think law licensing regimes are even necessary? Should control be wrested from the court, or could there be a competitive association structure of some sort?
Well, I mean, what you just did is you threw red meat in front of a predator, because that's the kind of question I really like. Well, first off, I think there really are some constitutional problems in forcing somebody to join an organization when that's not really related to the qualifications to practice law. I do believe that law is a profession like medicine, which should be licensed, but I think there ought to be more avenues toward licensing. And let me give you one example of what I mean. The Montana Supreme Court says that in order to take the bar exam in Montana, you must have a degree from an American Bar Association accredited law school. Now, the American Bar Association is an organization which does a lot of good things, but it's also pretty far left in many things, and it forces law schools to adopt certain policies that maybe most people on this call wouldn't agree with. Its accreditation standards for law schools don't always make sense. So one thing we could do is drop that requirement of being graduated from an ABA accredited law school. We might cast the net more widely, or we may simply say, look, we might require law students to be educated in law offices, or just say, if you take the bar exam, you get to be a lawyer, and then make the bar exam really tough, not hard. I think law needs to be a more open profession than the Montana Supreme Court makes it. When you are a member of an organization that's created by the Montana Supreme Court, where the Montana Supreme Court is participating regularly, and you attend the meetings, and you come under, directly or indirectly, you come under constraints. If I, for example, walked into a Montana Bar Association meeting when I was at the University of Montana, I'm not sure what my reception would have been. And most lawyers in a state like Montana want to avoid that kind of problem. So if you want to encourage dissent, one way to deal with it is to find a way to eliminate the integrated bar, and to do so before the US Supreme Court eliminates it for you.
Excellent. Okay. I actually have a question that I wanted to make sure I asked, because I'm curious, in your presentation, you talked about how the Constitution reserves the judicial branch only the judicial power. And there's limits in American jurisprudence on judicial power. You mentioned standing and rules for justiciability, and also avoiding inherently political questions and that doctrine in the courts. That doesn't seem to be defined specifically in either the US or the Montana constitutions. It doesn't seem like standing is specifically lined out, for example. Is that an oversight of the constitutions of both the US and the Montana Constitution in your view? Is that something that needs to be maybe better defined?
No, it's not an oversight. In order to avoid excessive length, both the Montana Constitution drafters and the drafters of the US Constitution put words of accepted meaning into the document without necessarily defining them, knowing that later readers of the document would look back and understand what those words meant. So, for example, in the US Constitution or Montana Constitution, they refer to trial by jury, right? Well, how do we know what the composition of a jury is? How do we know that there are preemptive challenges for a jury? How do we know that a criminal jury has to be unanimous? We know all those things because those are the prevailing rules as they existed at the time the Constitution was adopted. Another good example, which has come up and will probably come up again in the Montana legislature, the term in Article 5 of the US Constitution, Convention for Proposing Amendments. What is that? Well, that was well understood and known at the time of the ratification. So to actually interpret all of these, to define all of these terms would take the Constitution and turn it into a ponderous tome. And one of the goals of good Constitution drafting is to avoid that. The judicial power, that phrase, was fully understood by the time of the American founding. As was the related phrases, cases and controversies. So we knew that incorporated rules of standing, other rules of justiciability, of which standing is a part, the political question doctrine, and so forth. So you don't have to go far to find those definitions. You go on the internet and enter the term justiciability, and you'll find some websites that explain what the rules are. It's all, there are always questions around the edges with law, but in general, the rules are pretty clear. It's also pretty clear that the Montana Supreme Court, when it's got a favorite cause or a favorite plaintiff, just doesn't follow the rules.
Okay, let's see here. So we're past 7 o'clock now. So I think what we'll do is we'll take 3 more questions then we'll close, if that works for you. We have a question from Tracy, and Tracy says, you've described the bench as an oligarchy, and that's clearly evident. Wouldn't ignoring their rulings by the other co-equal branches be a suitable way to rein in an obviously tyrannical judiciary? I guess Tracy's hinting at possibly a doctrine of nullification potentially. So what is your take on that?
The recent case where the court, again, improperly, in my view, ordered the Secretary of State to poll the legislature. I think the court interpreted the Constitution wrong. Could the Secretary of State simply say, I'm not going to do it, I'm going to disregard it? I would not generally recommend that course of action. There may be extreme cases where it's necessary, but I'm not prepared to recommend specific instances in which that should be done. I don't think there's always, there's an ultimate arbiter to this, and that arbiter is the people of the state of Montana. And I just don't think that enough appeal has been made to the people, and that enough explanation has been made about the risks, the stakes that there are here and what the court is doing. I've noticed that that some members of the legislature, however, are becoming increasingly aggressive about reporting this, and I think that's a very good sign. I think the Frontier Institute's decision to do this study is a good sign. So we're going to see more of it. I think there's more awareness of it than there was when I was speaking on the issue 20 years ago. So I guess the answer to the question is, before open defiance of the court, I think that an appeal, a strenuous and consistent appeal to the people, needs to be made first.
Okay. I have another question that came in from Bart, and Bart, I'm going to try and summarize your question if that's okay, because it's a little bit lengthy, but essentially Bart's asking about citizen grand juries and whether that is a potential solution here. He says Scalia wrote that the majority opinion that said our judiciary is not to control our citizens grand juries, yet here in Montana, it requires a district court judge to authorize the impaneling of a citizens grand jury. Rob, your take on that?
Well, there are two kinds of citizen grand juries. Those are impaneled by a district judge in Montana, and those that simply impanel themselves. Those that impanel themselves are not going to have much effect. If anything, they're going to be marginalized in the media, painted as a bunch of crackpots, and that's going to be the end of it. Getting a citizen grand jury impaneled by a district judge, yeah, it might happen, but if the topic is going to be investigating the Montana Supreme Court, good luck. Remember that the judge is subject ultimately to the discipline of the Montana Supreme Court. So I don't really think that's a viable solution.
Okay. This is an interesting one, and this is a more recent case than I believe was covered by your issue paper, but it does bring up an interesting question. The Montana Supreme Court, what do you think about the decision of the Montana Supreme Court to interpret legislative rules? Essentially, recently, if you weren't following, Rob, the Supreme Court came in and said essentially that the way that the legislature was conducting themselves per their own rules was in violation of the Constitution. Your view on that?
Yeah, I have read that case, and specifically what the court was deciding as to whether to award attorney's fees in favor of liberal plaintiffs. It is in fact the case that Senator Hertz cited in his op-ed, which I talked about in my initial presentation. It was the second of those two cases. The court went into the legislative rules and said, well, you know, one reason we're going to assess attorneys' fees against the state is because the legislature proceeded in bad faith. It proceeded in violation of its own rules. I don't know if the powers of eloquence that I have are sufficient for communicating how utterly subversive that approach is. The right of legislatures to establish their own rules, unreviewable by the executive or judicial branch, is a right that is hundreds of years old. It actually antedates the US Constitution. It dates to the early 17th century, when Parliament had to vindicate the right to control its own rules against the overreaching of the king. It's fundamental to our constitutional system. The court's venture in this area was obviously entirely inappropriate. The court, of course, claims it wasn't actually rewriting the rules or interpreting the rules. It was simply using it as a tool to determine whether there was good faith or bad faith here. That dog won't hunt. The legislature needs to tell the court in no uncertain terms, back off. It needs to do so cautiously, however, again, because you're dealing with the media. Don't, for example, threaten something like impeachment, which you can't carry out. Nevertheless, the legislature needs to find a way to tell the court to butt out. The legislature's rules, and even the right of the legislature to change or violate its own rules, is its own concern. It's not the concern of anyone else other than the legislature and the people who elect legislators.
Okay. One last question, and then we'll wrap up. And this is an interesting one. So, what tough questions should the people on this webinar and attendees here be asking our judicial candidates, and particularly the candidates who are running for U.S. Supreme or Montana Supreme Court? What tough questions should we be asking to get a sense of those candidates' stance on the rule of law broadly, and particularly their stances on judicial restraint, sussing out whether they'll be an activist judge or a restrained judge? Rob, your recommendations.
My recommendation is to not pay too much attention to any answers they give you. I mean, there's a script in running for judge, right? Any judge. You're going to be tough on crime, right? Because nobody's going to say, by golly, if you elect me, I'm going to be soft on crime. They're not going to say that. They're not going to say, well, I'm going to invade the province of the legislative branch, so you should elect me. No, they're going to say they're going to be restrained. And they're going to say that, yeah, I'll interpret the Constitution as it really is. There have to be other ways. I like the idea, if it can be done, mostly of electing people to the Montana Supreme Court who have served on the district courts. Look at the record. If a candidate has served on the district court, look at the record there. Now, it's not completely the same, right? But if somebody on the district court is widely acknowledged by Republicans and Democrats, liberals and conservatives alike, to be a good judge, that's a very helpful indication. If the candidate for the court has prior political activity, a clear political identification, that's useful information. If I know that a candidate, this is a nonpartisan presentation, right? But of course, I'm a Republican, so I was active in the Pachyderm Club for many years. If I know that a judge was an active member in the Pachyderms for years, that tells me about that judge's philosophy. If I know that the judge was involved in representing organized labor, that tells me something about the philosophy. So you have to look at the judge's background, either as a district court judge or as a political figure, in order to get the truth. Because the questions that you ask, Kendall, unfortunately, are really unlikely to be useful. H.L. Richardson, the California state senator who started Gun Owners of America, once told me that he was very deeply involved in screening political candidates. And so the question he would ask a political candidate is, what's your favorite book? Well, that's a good question for a judge, I think. I really think it is. What's your favorite book? Well, many candidates who are savvy would say, by golly, the Bible. And so H.L. Richardson would follow up with the following question. Well, Mr. Candidate, what book of the Old Testament is your favorite and why? This is a way of separating out the flim-flam artist for the person who really takes books in general and the Bible seriously. So it's a legitimate question, I think, to ask a judge. That's a legitimate question to ask a potential judge, simply because it tells you something about the judge's values. Now, if the judge's favorite book is Gone with the Wind, I don't know if that's really a disqualification, but it does tell you something about the candidate. But simply asking the judge whether he's going to be a judicial activist or tough on crime, that ain't going to cut it.
Well, I think that's a great note to end on. And I'm going to just go over a couple housekeeping items for everybody. Again, this is the start of Frontier Institute's work in this issue area. We truly feel that this is an area that needs more expert analysis. We want to bring in more experts like Rob in to provide commentary and research, diving into the issues that are involving our courts here in Montana. If you came in late to this webinar and missed, the first half, we will be recording this, and we'll be posting a video that you can review at a later time. So hopefully you can go back and catch anything that you missed. Additionally, if we didn't get to your question, we definitely had a lot of them. So if we didn't get to your question and you want to follow up on it, please reach out to us. You can reach out directly to me. You can reach out through our website. You can reach out to Frontier Institute staff, and we'd be happy to help try and get you answers. This is part of how we want to do things is an ongoing conversation. And so part of doing a webinar like this is we want to be in open conversation about these issues. This is something that we should be engaging anybody and everybody about. So please reach out to have some follow-up conversations. I'd love to chat with you either in person or on the phone, doesn't matter. So Rob, I guess any closing words from you?
No, thank you very much. I've been in exile recently, as you probably know, here in Colorado. Have not been in Montana for the last 7 months. Will, however, be up in a few weeks. I very much look forward to being there again with my family. And if you've got any questions about this, feel free to forward them through Kendall, and I will respond if I possibly can. Thank you all very much tonight.